Okay, we'll just jump right into everybody's favorite topic of conversation, new legislation. And as much as it is wonderful, as I said, to be back with everyone, the one probably true advantage of virtual meetings is I couldn't see you fall asleep or start playing solitaire or generally tune me out during new ledge. Now I can, so to spare my very delicate feelings, do try and stay awake. We're going to do this very short and sweet, so hopefully we do keep you going. There were a few bills that have become laws, and I've gone over theirs. I removed any that died, so hopefully we're only talking about pertinent information. I tried to basically focus on the ones that affect your office, although I did include a couple that affect your county as a whole. There will be a digest in June or July that has all of the counties in that. So if you're a legislation junkie, you can always look at that as well. I do this presentation for all of the offices. So if you're interested in a particular office and you're a glutton for punishment, you can always watch those as well. No one's ever taken me up on that, so you could be the first. Okay, House Bill 1002, this has been signed by both houses. I don't really understand how important this will be, but I'd point out to you, it does have within it the specification that a government entity or employee is not liable if a loss results from an act or omission arising from COVID-19, unless the act or omission constitutes gross negligence, willful or wanton misconduct, or intentional misrepresentation. It's just to protect you for everything that we went through in the chaos last year. House Bill 1030 went through several reiterations. The current one, this has been approved and signed by both houses. The original language would actually have allowed the commissioners and the council to approve a unanimous ordinance by both boards to remove an elected officer. And by elected officer, I mean an auditor, treasurer, recorder, surveyor, or assessor. Those are the only ones. From their office if they were not in their office at least one day per month, barring a vacation or sick leave. To retain their office, the official would have to file a case in court. However, as we all know, elected officials don't have vacation or sick time, nor do they track their hours, so that would have been a problem for y'all. So that original bill was modified. The commissioners and the council can now initiate an action in court to remove an officer for the neglect of duties. The court would then make the decision, not the governing boards. This allows the officer to remain in office unless the court decides otherwise and continue to receive compensation. At the last week, I think, of the session, language was added to the bill that a county officer could be removed for failing to be physically present in the county officer's office. And it defines physically present as being physically present in the office during regular business hours for a reasonable amount of time each month. The bill does not define reasonable. You are elected to your office. You serve 24/7. We don't really think, I'm not a lawyer, I don't really think this would ever actually get through a court. They're going to be very loath to take an elected officer out of office. However, just so that it's on your radar, it could happen. You do not track your hours. You don't have any way to prove you've been there. On the other hand, they don't have any way to prove you're not there. If you get some kind of idea that someone's looking out for this, you might want to keep at least some sort of informal calendar or log to show that you are doing your job. As long as the office work is getting done, that's what's really important. But again, just to let you know it's out there. Recording requirements. This is House Bill 1056. It's become public law number 2. I want to point out as we go through the next several bills, as we've discussed together in earlier trainings, It is not your responsibility to determine if a document is legal or not. That's outside your office requirements. You have to determine if it meets the requirements for recording, not if it's going to hold up in a court of law. The main statute that sets out the requirements for recording is Indiana Code 36211. That's your statute, the recorder statute. However, Indiana Code 32212 is the recording process for property, and House Bill 1056 amended Indiana Code 32212. The big change, which you probably are all aware of, is that it clarifies that to be recorded, the instrument must have either an acknowledgement or a proof, but not both. Yay! This bill also adds instances in which an instrument is considered validly recorded for purposes of providing constructive notice. It provides a definition of proof, specifies who can perform a notarial act. And there is an amendment in this on the priority of recorded transactions. So it's information that's good to have. I think the biggest thing is now either or, not both. House Bill 1169 on cybersecurity incidents. This was also signed by both houses. So a cybersecurity incident may consist of one of the more or more of the following. We're talking about ransomware, business email compromise, vulnerability exploitation, zero-day exploitation, distributed denial of service, website defacement, other sophisticated attacks. The state's IoT department is going to maintain a repository of incidences for the state as a whole. Political subdivisions are going to be required to report any incidences to the repository maintained by IoT. Oops, cannot get this to work the way I want it to. So cyber attacks are unfortunately becoming more frequent as your office moves more towards electronic access, electronic records, collection of fees electronically. You're going to become more vulnerable to these type of attacks. Your own IT department can assist you in training to prevent these type of attacks. But as you know, simply opening a suspect email can be enough to allow malware to shut down your system. So be aware, and now be sure to report. As we get more information on the form or how this needs to be reported, we'll get that out to you. House Bill 1231 on lien removal fees. This amends your fee schedule in 362710. It's effective July 1st. What it does is adds a subsection and C on your fees that a $25 fee can be required to release a lien regardless of the number of liens held by a political subdivision on the property for a property that is sold or transferred under Indiana Code 6-1-1-24. Or I have that extra 6.1 in there, or 36111. So the 6-1-1-24, that's when your county sells a certificate of sale. And the 36111 is when a political subdivision sells their own property. So what this change allows is if the property is sold under one of those two, and if say a utility has 3 liens on there, they can release all 3 liens, recordings on all 3 liens with one $25 fee instead of paying one for each one. Because the law says so. It's sale of tax certificates. So the commissioner sale on tax certificates when it doesn't sell in a tax sale, or when the political subdivision sells it themselves, like a school would sell its own property. So it shouldn't be real common, but it is out there. House Bill 1255 was on probate and property matters. It was signed by both houses. There was a whole bunch of language on wills and trusts, which we're not going to go over. Thank you. You're very welcome. However, it does cover changes to conveyances of property under Indiana Code 3221, which we just said is on conveyance of property and the recordings for those. So we discussed that when we were talking about 1056. Again, I'm pointing out to you, you are not responsible to determine if the document is legal or not, just that it meets the requirements for recording. The first section of that did change requirements for the writing requirements for these documents. So the things you're going to be getting may look a little different, and I've just listed them on there, which sections were repealed or which sections were modified. Again, that's just for your information. It also made changes to 32-21-2, which is the recording process that we already talked about, that you only need a proof or an acknowledgement, not both. This made additional changes to that section of the statute. It repealed some of the sections and modified others. Indiana Code 32-21-2-6 now states that an instrument that complies with this article, which is 3221-2, 3342, which is notaries, and 36-11, which is your statute, is entitled to be recorded. And this does agree with the language in 1056. In section 7, it sets forth the form of an acknowledgement. It's pretty long, but you can look at it to see what it looks like. In section 8, the duty of the officer to explain the deed to the grantor has been repealed. In section 9, the certificate of acknowledgement is amended for what is required to be included with the instrument. Bring everything in line. And in 11, it says if an instrument is recorded without acknowledgement or proofs, certificates as required, the instrument may not be read or received in evidence. And that kind of reinforces that it's not your job to determine whether it's legal, it's the courts. So that's where they're saying it would not, even if it was recorded, it would not be legal. It made changes to 31-21-2.5, and that's your electronic recording statute. This is important. In section 7 of that chapter, electronic document can be accepted if it is in compliance with this chapter on uniform real property electronic recording with 3221-2, which is the property recordings, Indiana Code 36-11, which is your statute, and notaries 3342. Okay, and again, the acknowledgement or proof is defined now in 3221-2-1.7, which was in 1056. This is important. On or before July 1st, 2022, so you have a year, a little over a year, a county recorder shall receive for recording, indexing, storage, archiving, access to, searching of, retrieval, and transmittal all electronic documents proper for recording. A county recorder shall also accept electronically any fee or tax that the recorder is authorized to collect under the applicable laws. You have to accept electronic starting July 1st, 2022. I'm sorry? It just says recorders. Sorry. It does not say auditors, it just says recorders. Electronic documents, yes. 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 Also in House Bill 1255, they added a section to your statute, 36-11-3, If a county office is closed for 3 or more business days pursuant to an executive order issued under IC 10-14-3, the county executive and the county recorder shall provide notice to the public on an internet website maintained by or on behalf of the county executive and the recorder. The notice must be provided to the public within 5 business days of the executive order being issued. The notice may include information on how the public can submit documents to the recorder's office in paper, electronic, or digital formats, and how payment must be provided for services rendered by a specific county office. A county office failure to comply with subsection B shall not invalidate any instrument submitted to the recorder pursuant to Indiana Code 291723D, 3221, this chapter 36-11, or subject the recorder, the recorder's office, or the county office personnel to any civil liability. In addition, it amended 32-11-16, and that talks about what is required for recording. Section C has been amended, and it deals with it specifies instruments that a recorder may receive for record. For the name of each person who executed the instrument, the phrase "or logically associated with the instrument" is added for the legibly printed, typewritten, or stamped name. That phrase, again, I'm screwing up here. That phrase is also added for the name of each witness that's printed and the name of each notarial officer that's printed. And it also adds the definition of the proof found in 32-21-2. Adds a new subsection 5 that the execution of the instrument and the acknowledgement or proof as defined complies with Indiana Code 3342 on notaries. Okay. 1271 was the LGF's bill, which is usually pretty big, and it was pretty big this year. Nothing really directed to your office. I just wanted to bring your attention to it. Probably the biggest thing to be aware of for you guys is that it does increase the amount that a unit can transfer to the rainy day fund, so it's allowing your county to save a little bit more money through 2024. House Bill 1437 has been signed by the governor. Again, this bill doesn't affect your office directly, but it does affect how your meetings are held in your county. So it is allowing electronic meetings and signatures going forward. We saw a lot of that during COVID because it was the only way to get business done. So it's now setting out parameters to continue to do that. So it does allow a member of a governing body of a political subdivision. So this is your your commission, your council, your other boards, to participate in a meeting electronically as long as there is a written policy adopted establishing procedures. There is technology that allows simultaneous communication between the members and the public. 50% of the members are physically present. The bill does allow members attending electronically to be counted as part of the quorum, and the member attending electronically can participate in the final action. They can vote. It also provides that if a statute requires a manual signature for attesting an obligation, an electronic signature has the same force and effect as the manual signature. Senate Bill 28 on tax sales, and again, this doesn't usually direct you or affect you directly, but there is a section in this 6-1.124 about forfeiture. It's rewritten that section on forfeiture of a tax sale under certain conditions. The treasurer is responsible for the notification of the forfeiture, so they determine whether there is a forfeiture on a tax sale. But they must now file with the recorder a certification identifying the forfeited sale that includes the date of the sale, the name of the buyer, the property identification number of the real property's legal description, and a statement that the sale has been forfeited and is null and void because the buyer was not eligible to purchase the real property. This is effective July 1st. There's also another certification they can give if they determine that they could forfeit a tax sale and they choose not to. They will file with you a certification that says they are not forfeiting the tax sale and that the sale is still valid. And that is all I have for you. Are there any questions over any of this besides the fact that neither Ricky or I are a member of the General Assembly? We do not vote on any of these laws.
Hold on, I got one right over here. Hi, I'm Sherry from Lake County. On the tax sale certificate that the treasurer will present to us, do we charge them?
Technically speaking, you can, but it's a county paying the county. So usually we're not going to take audit exception if you don't,
Okay,
because it's going to come out of general fund into general fund or
Okay.
perpetuation. So you could.
well, I like when they're close by.
I don't know if I got this right. You were talking about the rainy fund. How is that affecting us or
I'm sorry, the what fund?
Rainy day fund.
the increases in the rainy fund?
They can put now up to 15%. They could only used to only put 10%. Until 2024, they can put 15% in the rainy day fund. So that's going to affect the overall budget for the county.
Mhm.
So if they're moving more money in the rainy day fund, that's less money available for the departments.
Okay.
That's all I meant.
Oh.
Geez. There's a notation in here that the notarial acts of acknowledgement and proof don't have to be done anymore as a pair. Only one has to be done or something like that. Can you explain that? Simple.
Could you probably explain better how this came about where it ended up with both?
I just want to know what it means. I don't,
One or the other, not both. You only need one is what it means.
what are they?
The witness page that they used to have.
Why didn't you say so?
Right.
The witness page is no longer required.
I haven't looked at the chat because I've been down here.
Oh.
I don't know.
So